So I just want to start by thanking the university for having me. It's a pleasure to be here. So this is Copyright 101. I think Ashlyn started off by doing a really great introduction and letting everyone know and informing everyone just how pervasive creative works are and that they're in every industry and every market, and we encounter them in everything we do day to day, and how people are claiming copyright infringement for all sorts of crazy things, from sweaters to movie posters to you name it, there's probably a copyright suit about it. And Kim did a great follow-up explaining how creative works and copyrighted works really can be commercialized and how they have value. I'm going to kind of take a step back and give you a crash course on what copyright law is, what it isn't, what its sources are, and hopefully I can shed light on copyright and maybe debunk some common misunderstandings that people have about the role copyright plays in society. So skip the agenda. So as Kim noted, the copyright law goes very far back, and it actually has its origins in our Constitution, in the Patent and Copyright Clause. Or if you're a copyright attorney, you just call it the Copyright Clause, because that's all that matters. So in the Copyright Clause, it says, Congress shall promote the progress of science and useful arts by securing for a limited times authors the exclusive rights to their writings. So copyright law as a concept is as old as our country is, and we actually borrowed the system from England with some modifications. That being said, we've codified it with various copyright acts that also go back centuries, and we've updated them through overhauls throughout the years. But it's kind of a Frankenstein state of our Copyright Act, because we've overhauled it, but we've built on what was there previously, and a lot of people think maybe we're due for another overhaul to clarify and simplify what our Copyright Act says and how it's interpreted. Because right now, we're basically dealing with the last major overhaul was in the 70s, and as you can imagine, technology has changed substantially since then, so we're trying to fit current technology into concepts and definitions in an act that used the word phonorecord to give you some context of just how outdated it is. So copyright law is, as I said, nebulous, complicated, and based on overwrought and outdated statute that maybe someday will get updated if Congress can agree on anything. But for now, we have to do the best with what we have and make sense of it. It applies to many aspects of our daily and professional life, especially in academia, where you're constantly relying on texts and written works and artistic and visual works and movies and music in the classroom and in scholarly works themselves. Despite the fact that we encounter it every day in basically everything we do, there's a lot of misunderstandings about what copyright is and what it isn't, and what your rights are in your own works and what your rights are to use other people's works. This is especially true on the internet, where sites like Pinterest and photo sharing and stock photo images, people are sharing everything in this social media age, and it's not always clear what right they have to do so and how they can best protect their own works online as well. Generally, the basic purpose of copyright law is to protect the creative works of an author or an owner from the copying or other misuse of that creative work by a third party, someone who's not the author or owner. And copyright law endeavors to strike a balance between protecting the author, incentivizing authors to create works with the confidence that their works will be protected by the law from this abuse and misuse, so they can commercialize it and benefit from their own hard work and creativity. But copyright law also keeps in mind the flip side, is that we want to encourage a rich and open public domain where information can be exchanged and shared easily. And for that reason, copyright law, like patents, only affords protection for a limited time, a short duration. As I'll get to later, it's not really a short duration anymore. Initially, when copyright law was first codified, I think the term was 14 to 28 years, depending if you renewed. Now it's well beyond that, but we'll get to that a little bit later. And it raises questions of whether that balance that was initially trying to be struck is maybe not so balanced anymore and might need to be reconsidered. So what copyright law is? As I mentioned, it's to protect creative works from copying or misuses by third parties. As we kind of heard a little bit earlier today, it covers a lot of things. It covers creative works of original authorship expressed and fixed in a tangible medium. That's a definition that we're going to unpack a little bit later. But it really extends to works in a lot of different mediums. Literary works, anything you write, pretty much. A book, a poem, a play, a screenplay, anything you put in writing that has some degree of creativity could be protected by copyright, even if it's something maybe that you consider banal. If it has that degree of creativity, a written work can be protected by copyright. Musical works, both in terms of lyrics, which I guess would be the literary works, but also the musical notes and the orchestration and the melody of a song. Dramatic works, such as performances, if they are recorded, choreography, motion pictures and audiovisual works, sound recordings, architectural works. Video games have just recently been officially recognized by the Supreme Court as being under the purview of copyright law. To me, that seemed kind of obvious, but it's been decided, so there's really no more debate about it. And I say et cetera because it's definitely the subject matter is definitely going to evolve and grow as people come up with newer mediums of expression. We can only imagine what could be copyright protectable in the future, just hasn't really been expressed in that medium yet. And what copyright, so that's what copyright extends to, and the copyright law provides the owner or the author with a bundle of rights, exclusive rights that the owner has and no one else in the world has. What copyright law is can also be kind of conceptualized by what it isn't. And what it isn't are the other branches of intellectual property law necessarily. So we have patent law. This is kind of rehashing what Kim talked about, but patent law generally covers two different things. Utility patents are used to protect utilitarian products, functional, useful products, goods like inventions, and processes. Those are method patents, so how something is done, how something might be made, or how a business executes a certain goal could be a patentable method. And then there are design patents that don't protect utilitarian aspects of something, but they protect the purely ornamental design features of a product. Copyright law is also not trademark law, which focuses on protecting any words or symbols or phrases or really anything, again, sense and images and motion marks that serve as a branding device or a source identifier for a company or one of its products. So while there are these three distinct fields of intellectual property law, there is overlap, obviously, and certain works and products could be encompassed by all three types of intellectual property. Utility patents, for example, could cover software, which is a contentious issue, but software is also protected by copyright law in that it's written source code. It's a text, in a sense, even if you can't see it necessarily when you're using that software. Design patents obviously have a lot of similarities with copyrights in that they focus on things that aren't functional and utilitarian, but on design and ornamental things. So you can imagine a situation where a product could be in both the world of a design patent and copyright protection. And there's also some intersections with trademark law as well, to the extent that a trademark logo or design has creative artistic elements to it. If you think of the Starbucks logo, the swan or siren or mermaid, whatever she is, that green design, that's clearly, you see it and you know that means Starbucks. You don't even have to have the word Starbucks there. You know it's Starbucks, and that's what makes it an effective trademark. But the design itself was created by someone, and that artist had copyright in it that, it was assigned to Starbucks, I'm sure, or maybe it was a work made for hire. But That's an example of something that had both copyright protection and trademark protection, though the true value is surely in the trademark. So earlier I said that the subject matter of copyright is really anything you can think of that fits into this definition of an original work of authorship that is fixed in a tangible medium of expression. And these seem like very legalistic words, so we're going to unpack that a little bit. What does that mean? First, there's the requirement that it's an original work of authorship. And to be original to the author must have taken some individual actions that required just a minimal degree of creativity and choice. It's really, really quite a low threshold. All it means is that they had to have made some decision somewhere along the line that had a creative impulse, something that they were inspired by, and they took that creative impulse and they made something out of it. For example, they could have photographed something, and just the creative decisions in photographing something was maybe what the lighting would be or where they would be positioned as the person holding the camera. However, although it is a low threshold, there are a lot of things that don't meet that originality requirement. Things like titles and names and short phrases and slogans typically aren't considered to be something that meets that originality requirement. That's a general statement. There's typically this inverse relationship between originality and length of a work. The longer something is, the more likely it is to have a creative element to it, and the more likely the author is going to be able to establish that they put some of their own inspiration into it rather than just having it be something basic or common or familiar to people. Common symbols or tropes, things that are commonly used, probably not going to be original. Something that is a known fact doesn't really display any originality or creativity on behalf of an author. A mere listing of ingredients in a recipe. This is something that some people find surprising, is that a recipe typically is not going to be protected by copyright because you're just listing ingredients that you put into something and how much of each ingredient you put into something. And that alone is just, it's basically instructions. And it's considered, either fact or something that's useful and not creative. So that's just the recipe part. But if you provide instructions on how to do something and you have a written text about that recipe, then that is something that the author might have put their own creativity into and would be protected. And lastly, I have works created by others with your own equipment, but not at your direction. This gets into an interesting thing, and it kind of gets into authorship, which we'll get later. But the work not only needs to be original, meaning that it has to have some creative instinct and impulse, but it also has to be original to the author. Some of you might have heard in the news last year that there's this famous case where a photographer was out in the jungle somewhere, I don't know where, but he encountered a monkey, and the monkey took the photographer's camera from the photographer and took a selfie. The monkey took the camera and started taking pictures of itself. And they're great photographs, and they took the internet by storm, and the photographer tried to claim copyright protection in the monkey selfie. And it was this big question among everyone is whether he or she could do that. I don't remember who the photographer was exactly. But before this went to court, the Copyright Office stepped in to clarify that, the author has to be having some control over the creation of the work. And if a monkey or someone else just took the author's equipment and took a picture of themselves, that doesn't give the author any kind of creative choice or control over what was created. The author's only contribution was the fact that it was his or her camera. So that's not sufficient. The same can be said of equipment or machinery, depending on how much control and creative choice the author has over what that machine or equipment is doing. But it's a pretty low threshold, like I said. Something that isn't included in the originality, as Ashlyn noted, is the famous case about the phone book listing. It's just a listing of addresses and names in the ordinary sense that you would encounter them for them to make sense in a phone book. And that alone, although it might have taken a lot of work and effort on behalf of the person who put it together, wasn't protected by copyright law, because copyright law doesn't really care how much work or effort you put into something in terms of how much time it took you, but how much creativity and creative energy and inspiration you put into whatever you created. So turning then to the other requirement, that it be fixed in a tangible medium of expression, this requirement really speaks to the fact that it has to be tangible in some sense, that it can be perceived and communicated and shared and observed for more than just a brief transitory period. It has to exist more than just fleetingly. And the fixation requirement also highlights this key distinction between ideas and the expression, the specific expression of an idea. Copyright law does not protect a general abstract concept or idea, but what it does protect is the specific fixed expression of that idea. And the reason, again, that it draws this line goes back to that core purpose and balance that it was trying to strike earlier, and that it wanted to promote the useful, or the progress of useful arts. And essentially, copyright law didn't want to have people claim protection for broad categories of ideas, because it would really stifle the innovation of other people who might have the same idea, or might want to take that same idea, but might have a completely different way of expressing it. So if you think about this in terms of stories, an idea might be, or like a literary story or a movie, an idea could be a Western in which a cowboy has to rescue a damsel in distress. It's been done countless hundreds of times, who knows? But every person who's done that story has expressed that idea in their own way. And that's what copyright wants, is to encourage lots of different expressions of similar ideas. So that's what copyright law covers, the subject matter. What does copyright law afford the owner or the author? It gives them, as I mentioned earlier, a bundle of exclusive rights that no one else has. Typically, the most valuable of these rights, though that really depends on what kind of work you're dealing with, is the reproduction right, the right to make copies of the work, and the derivative work right, the right to make adaptations, translations, sequels, cross-medium, I guess adaptations if you wanted to turn a book into a movie or vice versa. But it also includes the distribution right, how and when you decide your work is going to be distributed to the public, the display right if you have a visual work, the performance rights if your work can be performed, and then also transmission rights for audio and sound recordings. I say among others because there's a few other things in the Copyright Act. There's a brief section of it that gives moral rights, which typically aren't recognized in the US but have greater recognition abroad. A moral right kind of takes a very humanitarian view of copyright from the artist's perspective, and it kind of guarantees that the artist has some protection in the dignity of the work that they've created. So the brief extent that the US does allow for some moral rights might be in the form of an attribution right or a right against mutilation of a work. But only certain types of works in the US can have that moral right. So we covered what copyright covers as far as subject matter and what it provides. Who does it provide it to? Leads us to copyright authorship and ownership. So ownership of copyright is distinct from the ownership of the physical article that might be embodying that copyright. So I can buy a book from the bookstore, and the author of the book has copyright to that book. But he doesn't have any rights to the physical article necessarily that I've purchased from that bookstore. And me as the owner of that book and the consumer can do with that book pretty much what I want. It's called the first sale doctrine. And basically, the copyright owner has a distribution right in the sense that he can decide how and when he or she wants that work to enter the public stream of commerce. But once it's there and once I've bought it, it is no longer under his or her control. So it's a distinction between the physical object and then the creative, copyrightable thing that that object embodies is what the author owns. Ownership in a copyrighted work vests in the author or creator of the work at the time of creation. So at the time that an author writes something or records music, that is when the author, the creator, has those rights vested in them. And it's the person who created it or directed the creation of it, in the case of an author working with someone else, that has those ownership rights. There are a few exceptions to this in a work that is a jointly created work. For example, maybe a scholarly article in which two people contributed equally, and it was their intention that it would be a jointly created work. In that case, both of them would be listed as joint owners and authors, and they would have separate equal rights, exclusive rights afforded by the Copyright Act. But more contested and complicated are a category of works called works made for hire. And this is particularly important in the context of academia and a university. Basically, a work made for hire is a work for which the creator or the author is not the person who ultimately owns the copyright, but rather it's owned by someone else, such as their employer or someone who commissioned them to create that work for them. So for the employer situation, a work is going to be considered a work made for hire if the employee is in fact an employee, not an independent contractor, and the employee created that work in the scope of their employment. So basically in the scope of what their basic job function is for that employer. This can get a little tricky in the university context because the scope of a professor's employment is by their nature something that is very creative, but it also is by their nature something that they have a lot of independence and discretion on what they teach and how they want to teach it. And beyond just the teaching function, they have, academic and scholarly pursuits that are separate, could be separate from what they do in the classroom. They could be researching and writing a paper, for example. So it can be a little blurry and uncertain whether something a professor creates either for a classroom context or outside of the classroom but for a scholarly pursuit would be considered created in the scope of their employment, which basically means it's blurry whether the professor is going to own the copyright or the university as the employer is going to own the copyright in whatever the professor created. Courts have gone different ways on different types of creations by professors. A lot of it is very circumstantial. A lot of it might depend on how much influence and control the university had over what the creation was, how much oversight the university had, and how much the creator might have relied on university resources. As you can imagine, because there's so much murkiness in the context of university and faculty created works, most universities have devised an IP policy that pretty much clearly sets out, here are things that you create and you'll own the copyright to, here are things that you might create and the university will own the copyright to. Basically just to sidestep any of the ambiguity that we would otherwise have to drudge through just relying on the copyright law. The other context in which works made for hire come to be are when basically someone's not an employee, but they're an independent contractor, and you want them to, for example, create some designs or drawings that you're going to put on T-shirts. And you want to be able to sell those T-shirts without the designer knocking on your door and demanding royalties or claiming that you infringed on their copyright. So in that case, what you would do is you would have them sign a work made for hire agreement. If you get them to sign in writing saying that this is a work made for hire, that they have commissioned you to make, and they agree that any copyright in that work belongs to you, the person commissioning it, then that would qualify as a work made for hire. And then in that case, the owner would not be the creator, but the person who commissioned the creator. Ownership of copyright can be transferred from one entity to another, one person to another, people to corporations, by written assignment. It's not uncommon, and they can also be licensed if the owner wants to keep it but wants to give someone else permission to use it. Well, other panels can go into the intricacies of licensing more. So as I mentioned earlier, copyright was initially designed to be for limited times. The words limited times are in the Constitution, in the Copyright Clause. And the purpose of that limited duration was, again, so that we could have a rich public domain of works that people could draw from and use and freely distribute. They could reproduce these works in the public domain without having to pay anyone or to pay a royalty or to, fear an infringement claim by someone. Due to, like I said, the many changes in copyright law, the incremental overhauls throughout the decades and centuries, the duration of a copyright varies significantly on when the work was created and on some other factors, such as when it was published and whether it was renewed or whether it was published with notice or without notice. So it's unfortunately not easy always to determine whether a mark is in the public domain or not, and if it's not in the public domain, what its duration is going to be. It's always important to check to the best that you can whether a work is in the public domain or what its remaining copyright term is if you want to use it. Unfortunately, there's not a searchable database, not a good one or a reliable one, where you can just punch in an author or a title of a work and see whether it's in the public domain or see what its copyright term is. I always find that a little surprising and baffling and something of a travesty. But when you think about how many millions and millions of works there are and the fact that they don't have to necessarily be registered, it's not terribly surprising that there isn't this database. But maybe someday we'll have a better resource for determining what something's copyright term is or whether it's in the public domain. For now, there's a few resources and websites. Cornell University has a pretty good guide for helping you determine what a work's copyright term might be, depending on the various factors of when it was created or published. But for new works, we know what the term is going to be. Any work that's created today is going to have a copyright duration of life of the author plus 70 years, or in the case of corporate authorship, such as a work made for hire by a corporation having its employee create something, the term is going to be 95 years from the publication or making public of the work, or 120 years from the creation of the work, whichever expires first. So let's just take a step back and appreciate how long that is, especially in comparison to the original 14 to 28 years that was originally devised when copyright law was first, enacted into a statute. We've gone from 28 years to life of the author plus 70 years. And again, life of the author is something that is getting longer and longer too as people are living longer and longer. So it really makes you wonder whether the limited times requirement of the copyright clause in the Constitution is really being respected anymore. Is it really a limited time when something is life of the author plus 70 years? People in favor of long terms, basically content creators, content industries, want to protect their works for as long as possible, obviously. And the the arguments that they provide to justify a longer term is that people are living longer, so we want them to enjoy the fruits of their labor for longer, and that we also want their children and grandchildren to enjoy the fruits of their labor. And that's probably all well and good, and there's some legitimacy to that, but we have to draw the line at some point. Can anyone in the room think of a work that is in the public domain that they routinely enjoy or experience, or I don't know how to phrase it, but my point is there isn't very much in the public domain because basically the work has to be from 1923 or older. And when a work is that old and it's finally entering the public domain, it doesn't have relevance anymore, really. Not to the extent that it would initially if it had entered the public domain 28 years later. Question? What was that? Very good point. Classical music is something we do appreciate. Shakespeare, very old classical texts we appreciate, and they're in the public domain. I guess my point was, if the point of a limited time was that so we would have a rich public domain in which things eventually would enter a public domain and they could be shared openly and freely. When the term is so long before something enters the public domain, it raises the question of when it does enter the public domain, is it going to be appreciated? Is it going to have any relevance anymore? Or has that period passed? And I think, I'm getting my own personal opinion into this a little bit, but I think maybe terms have gotten a little bit out of control when you think of the fact that The Great Gatsby, something that was written back in the 30s, is still under copyright protection, and to this day, Fitzgerald's great-great-granddaughters, I think, are still reaping the royalties from that book. It's something that we all read in class, but, maybe it's outlived its copyright worth in the sense that maybe it's time for it to enter the public domain. Tied up in this issue of copyright terms being very long and the fact that we have a very hard time of determining whether something's in the public domain because there's not any kind of searchable database, is this issue of orphan works. An orphan work is basically a work that was created some time ago, a long time ago, and it's not necessarily clear maybe who the author is, who owns it, and even if you do know the author, you might not know who owns the copyright, because oftentimes the person who's the author of the work, listed on the work, is not the same person who owns the copyright. It could be their estate, or it could be a company, or it could be a publisher, it could be anybody. And when we don't know whether something's in the public domain, and we don't know who the owner is, then we don't know whether we can use that work with impunity, without the fear that we could be infringing on someone's rights. And to some extent, this might stifle people's ability to use these orphan works in creative and useful ways that they otherwise would be able to use them if we knew that they were in the public domain. There's a lot of great nonprofit and organizations that are working on the orphan work issue, but it's an issue that's exacerbated by increasingly long copyright terms and not great resources for determining availability. I say subject to change because as copyright law has been updated throughout the years, almost every time that they've updated it, they've extended the copyright term to be even longer. The last extension was in 1998, when they added 20 years of copyright protection not only to newly created works, but retroactively to works that have already been created, meaning basically it was 20 years worth of work that would have entered the public domain that have been postponed from entering the public domain. And there's some speculation that in the future, when works are on the verge of entering the public domain again, it's only actually just 3 or 4 years down the road from now is when works might start entering the public domain again, that there's going to be another act passed by Congress extending copyright terms even to be longer, so these old works can stay protected for even longer periods of time. Again, you have to ask who stands to benefit from these really long copyright terms. Is it the public? Probably not, because we want a rich public domain. It's mostly creators and content industries. So Congress and the courts have to walk a fine line between weighing those two factors, because again, it's always a balance between incentivizing creators to make works and ensuring that there's a rich public domain. But yeah, in the years to come, look for headlines about Disney trying to protect Mickey Mouse, because Mickey Mouse is maybe on the verge of entering the public domain, but we'll see. I doubt it. So, yeah.
While enforcement might vary across countries, is the law the same for all countries, or is it only specific to the U.S., these provisions?
Enforcement?
Yeah, I mean, copyright, is the law the same across the countries, or?
Good question.
We hear about a lot of violations in different countries, so enforcement is going to vary anyway, depending on the local context.
Right.
But in terms of the principles of the law, is it the same across countries, or is it also just specific to U.S. what you're stating right now?
Good question. So the answer is yes and no. Every country is going to have their own specific codified copyright laws, but there is going to be a lot of similarities between them, as a lot of these countries are members of international IP treaties that basically have some overarching themes in terms of what their laws are going to encompass and what they're going to respect in terms of other countries' laws. So everything I'm talking about is specific to the US, but you might find a lot of parallels and analogies in other countries. Just on the issue of copyright duration, it varies country to country. And for example, in Canada and in the UK, a lot of written works are in the public domain, and they're not in the public domain in the US. I think Peter Pan, for example, is in the public domain in the UK, but it's not in the US. And this creates, this and a whole bunch of other copyright issues of infringement are really coming to a head in the fact that now everything is available online, everything is shared online. So if I'm a website in the UK and I'm offering public domain works for people to download for free, which they can do because it's in the public domain, how do I make sure that people from the US aren't accessing my website and downloading works that might not be in the public domain in the US? So it's the globalization of how we interact with creative works, I think, is going to lead to more and more unification of international systems of copyright protection in terms of duration and in terms of other aspects of the law. Copyrights in the US, a copyrighted work can be registered with the US Copyright Office down in DC. Registration, however, is not a requirement to having protection in your creative work. As I mentioned earlier, your copyright protection is vested in you as the creator the moment you express that original the moment you fix that creative expression in that fixed tangible medium. So you don't need to register to have those rights. You'll have them by virtue of just creating it. Why register then? There are a lot of benefits to registration. It's required for filing an infringement lawsuit, and it's a prerequisite for obtaining certain relief in any kind of infringement lawsuit or enforcement action. You can only get statutory damages, for example, if your works have been registered prior to infringement or within 3 months of publication. But basically, registration is a boon to your ability to enforce your marks against potential infringers and third-party misuse. And it also is a way of validating your rights and having a clear record of your rights, of when it was published, when it was processed by the Copyright Office. And then it also kind of might help us create some sort of database of what is copyright protected and what isn't. Copyright notice separate from registration, is not required anymore, used to be required, but is highly recommended. Copyright notice is the use of the C with the circle around it, followed by or next to the date of its publication and the name of the author or owner, if it's someone other than the author. And although it's not required anymore legally, it's still highly recommended because it informs the public that the work is a protected copyrightable work. Sometimes people might see something and it won't have a copyright notice on it, and they'll think, oh, just because it doesn't have a copyright notice, that means it's free to use, fair game. Not so. So having it might prevent those people from making that mistake. And it also prevents a party from claiming to be an innocent infringer, that they didn't know that it was a copyrighted work, if and when you get to an enforcement action against them for infringement. And it, again, also identifies the owner and the year of first publication, so third parties might have a good sense of who to contact if they wanted to license the work from you. So it helps us facilitate use and licensing. Below are two examples of notice. The order in which you put the three sources of information, or the three aspects of it, the symbol, the year, and the owner name, isn't important, but it is important that you include all three of them. So using the works of others is obviously something that happens frequently in the academic setting. However, using the works of others that is a violation of one of their exclusive rights as a copyright owner, like their reproduction right or their performance or their display right, without their permission would be, a prima facie, on its face, it would be an infringement of that exclusive right of that owner. Unless you have permission or unless it falls into a clear exception. Some exceptions to what would otherwise be infringement, I say, are amorphous, vague, and unclear. This would be the fair use doctrine. It's fascinating, and my colleagues Nate and Jessica will talk about it in their next panel that you should stick around for, and I'm looking forward to. But it is, even for copyright attorneys and people who have years of experience dealing with fair use cases, very difficult to predict whether something would be considered fair use or not, because there are so many different factors, and it's very context circumstantial, and it makes it very difficult for users of third-party works to have any confidence of whether what they're doing is fair use or not. And a lot of times this can maybe chill them from doing something that they otherwise would do, or might prompt them to get a license when maybe they don't need a license. So it's, it could use a little bit of clarity. And maybe that's something that if we do overhaul and rewrite the Copyright Act in the years to come, we could add a bit of clarity to. But then there are other exemptions that are a lot clearer to apply and to interpret. There are some exemptions directly written into the current Copyright Act. There's the Teach Act, which is specific to the university context. And then there are Creative Commons works that, again, Nate will talk about more. But basically, there are works that the author has given permission to the world, a license to the world, to use their works. And they might have put some caveats on how that work can be used or can't be used. But basically, they've said, I'm putting it out. You can use it without having to worry. Again, I note that a third-party work is not fair game for you to use simply because it doesn't have a copyright notice. It's a common misconception. Another misconception is that simply giving someone attribution, maybe citing them, prevents you from being accused of infringement. Not so. I mean, you did the right thing by acknowledging where you got something from, and maybe you weren't plagiarizing, but that doesn't mean you weren't infringing. And it's always best to try to get clearance, either to make sure you have an exemption or you have express permission or a license before you use something. And in the university context, I think most universities have departments that handle permissions and licensing. But outside of that, there are services such as the Copyright Clearance Center that help sort through this mess and help find who you need to get permission from, and they help you get permission from that person if they're willing to give you permission. And lastly, as I noted, the copyright law, the last major overhaul was in 1978. And since then, technology has just advanced so much that it's really been trying to catch up ever since. And there have been a few incremental acts that address very specific things, very specific intersections of technology and copyrights. One of them was the DMCA, the Digital Millennium Copyright Act, which was effective in 1998, which by now is pretty much already obsolete and outdated because so much has changed since then. But anyway, it was revolutionary, and it's actually still, it's not obsolete. It's still in force, and it still has relevance, but it probably could use updating like the rest of the copyright law. It basically had two main aspects. One was that it prohibited the circumvention of digital rights management protections that were built into creative works. Like a DVD might have a digital rights management, a DRM, that would prevent someone from ripping or burning or making a copy of that DVD. Or a piece of hardware might have a DRM that prevented you from otherwise engaging in copyright infringement. In my opinion, I think the more relevant aspect of the DMCA was that it really addressed the issue of copyright infringement online, what the liability was for the infringer, and what the role of the intermediaries were in these kinds of online infringements. So what kind of liability can a website have for the infringement of that website's users? Or an internet service provider, like a university that provides a network internet access to everyone, what kind of liability can they have for the infringement of people using their network? So this act really set forth a lot of pretty clear guidelines. I think it's a pretty well-written act for establishing what a university or an online service provider like a website needs to do in order to make sure that they are protected and they have this safe harbor protection from liability for infringing actions by people using their service or their network. And most universities and most websites and basically anyone who falls under this potential safe harbor has a DMCA or a online copyright policy posted on their website, making clear what their policy is. And they have a designated DMC agent where communications get sent through. But the gist of it is that the act tried to split the difference in that it didn't want to overburden an online website or a university network with an unreasonable expectation that they could possibly police every single use by all of their individuals preemptively to make sure that no one was infringing, or even after the fact that they would have some responsibility or burden to review everything to make sure it wasn't infringing, and if it was, to take it down. If that burden were placed on YouTube, where there's millions and millions of these videos that users upload, YouTube would shut down. They wouldn't be able to make that decision for every single video of whether it's infringing or not. And they wouldn't just, it would take so much manpower that it would be cost prohibitive, and it would really straddle innovation on the internet and impose just great burdens on these internet service providers. But they're not off the hook completely. They do have some requirements. They have to have an agent designated to receive complaints that could be sent by content owners. They have to respond to these complaints expeditiously. They need to, in the event that they have any red flags or if they have reasons to believe that certain content is infringing, they have an obligation to act on that. So it imposes kind of a via media of what an online service provider must do, what they don't need to do, and really what they should do in order to avoid liability for infringement that might have been at the hands of their users. So that was a very fast, high-level overview of what copyright law is. I basically tried to condense a whole semester of law school subject matter into an hour. So I clearly omitted stuff, and I just scratched the surface. And my hope was that it kind of gave you some foundation of copyright law, some language, and some building blocks for you to better understand the much more interesting panels that are going to come later in the day, like Nate and Jessica's next. And thank you for listening.